Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. All right, guys, let's jump right on into it. If you were just in the last live stream, you know the deal. We just came in from Classic Trials, cut it off, and now we are, boom, we are here. We are back in Milwaukee.
Mr. Brooks, and then an issue just as it relates to the record and the use of restraints during the trial, given a statement that was made by Mr. Brooks when the jury was coming out after they had reached their verdicts. So
he's already arguing.
I saw the parties should have received
that the verdict was
letter
proper.
Dated October 28th, advising the parties that the court will be unsealing all of the search warrants tomorrow, November 1st, unless there's an objection that is raised. Of course, that's based in law and fact. And I indicated in that letter we would address any objections at this hearing. So I'll start with the state. Do you have any objection to that?
No, Your Honor.
All right, Mr. Brooks?
Yes. I have not received anything. I'm quite sure, or I don't know if you knew, but the very second that I left your courtroom Wednesday, Your Honor, I was placed on suicide watch. I was told that it was per jail administration, that it was policy. It was nothing I could do about it. They immediately took me right from court, stripped my cell. I talked to mental health. They changed me right over into the SMOC, and I was basically placed on that. They just gave me regular clothes, maybe 10 minutes before I came to your courtroom, Your Honor. So I haven't. I wasn't allowed any
We'll give
mail.
it to you.
Huh?
I had the letter printed off, and we'll give it to you now so you can take a moment to review it. It really says everything that I just put on the record just now as well.
I accept for value and return for value this document.
I would just note there's a typo in your name, but so my apologies for that. Middle
He's like,
initials
what
indicated
name?
wrong.
I don't go by that name.
It does reference this case number.
Oh, Kurt in the chat.
When was
You wanna join?
this letter? Because like I said, I've been on
Can
watch,
send you a link
so
if you
I
want.
haven't been able to obtain any mail whatsoever. Not from the courts, not personal mail, not anything.
So that was signed on Friday and then sent over. I'm not sure if it was emailed or if it was just delivered to the jail. I don't know if Madam Clerk has any information. It was done by my other clerk, but in any event, you have it before you. What I can tell you, sir, is that normally search warrants may be sealed for a period of time. All of these warrants were set to be unsealed previously, but due to the pretrial publicity and the various orders related to the jury, including the use of the jury questionnaire, I had, at the request of the parties and with the consent of all parties, sealed or continued the seal on all of these documents, and the previous order indicated that everything would be unsealed either November 30th or at the conclusion of the jury trial, whichever came first. Of course, the jury trial is now concluded, even though the case hasn't gone to sentencing. So my intent would be to unseal everything tomorrow, unless you have an objection and it's based in law.
I have, like you said, this is my, I didn't even know that this was even sent over to the jail until right now, until you told me.
Understood. Do you have an objection to what I propose to do? So
I don't even understand. What do you mean by sealed and unsealed? I don't.
it would become a matter of the public record, and anyone could review those search warrants if they make a request.
Search warrants for what property?
There's a number of search warrants that have been sealed as it relates to this case.
From what I saw, everything's been pretty much public. I don't see why they need to be unsealed at this point. Everything's pretty much been public already.
All right, well, I am going to unseal them effective tomorrow. The clerk's office is instructed that first thing tomorrow morning, they may unseal all of the search warrants in this case. The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shock, shackles, or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. The parties will recall the tables look a little different now because there are no table skirts on them. On all defense tables in the secure courtroom, there is a ring. It's really more looks like a rectangle that is attached to the leg of the table, and an inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard. And then it's attached to the table so that it confines the inmate to a small area with that table. Obviously, during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public. And that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal,
Carol, you're so right.
Represent, you can certainly look
Cecily
at that.
Strong would do a good job.
Be under seal. So
why would that?
The record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So
well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
there was no shock device.
It was a shock device. I was told it was a shock device,
Mr. Brooks.
And
that's
it was
why
covered up.
The record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but it should be noted.
Your
it should be
objection is noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It's a fact.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm
my.
going to require about what's being put on my body. I was told that there were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is.
It's never
It was
good when he's saying,
clearly
I've
a
been
shock
through all of
device
this
that
before.
was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't
Brooks,
deserve.
you're-
The public deserves
You've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this
it's
voltage.
absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that is not false.
Well, I have the photograph
Well, show
that
the
will be part
where's the
of the record,
photographs? Where's the photographs?
and they
You
will
just
be
said they would be
sealed
sealed. Why do they need to
from
be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been
no.
proved for the record?
All right, so
Can we move on to that?
Mr.
Now-
Brooks, I really don't want to remove you from the courtroom today.
It-
But I need to move
I don't
on
want to
to-
be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record
Okay.
when you know that
Now-
it was in fact a shock device. That's why I had the black cloth in front of the table.
Now she
so it
should
couldn't be shown.
take more
That's
That's
control.
why I had
No.
a chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks,
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to move on to
there's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came to this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
Oh,
Mr.
geez.
Brooks,
Why
any
did I have a
further,
black cloth
any
in front of the
further
table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold me
letting
in
move
contempt.
on
That's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me
All right,
then. Remove me
Attorney
then.
Attorney
It's
Basie.
not going to stop the fact
Remove
that
him.
they
All
need
right,
to know
Remove
that
him.
shock device
he's
is on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom.
Oh,
We'll make
That's
appropriate
fine.
Tell the
findings.
truth, though, Your Honor. Tell the truth. I had a shock device
Captain,
on
can
my
I
ankles.
please see you? We're off.
Oh boy. Okay. So it's interesting because it's like there was a question about whether his behavior was going to change now that there's no more jury, right? But it does seem like this is obviously continuing in very much the same fashion. And I think the other element there is the cameras in the courtroom, right? Because he's saying, you know, he's talking about the people that he thinks need to know these things are the jury and the people watching, as in us. Like we are the secondary jury for him. It seems like. So it's interesting because it's like his whole performance is still continuing. Whether this is how he is in everyday life or whether this is some sort of amplified version of it because of the cameras, it's impossible to know. I mean, unless you know him personally somehow. But yeah, Maria in the chat, it must be exhausting to be him. I agree. I mean, how much of your time and energy is spent just fighting over things that are just not necessary? So, and for folks in the chat also, I think there was a question earlier about like do people actually have like shock anklets, you know, in these kinds of situations? I don't think so. I've never actually heard of that. happening in a courtroom like this. Um, having some form of restraint is a good idea if they are a flight risk. But I mean, having shocks on them, I don't know. That could potentially turn into an Eighth Amendment sort of issue, right? Cruel and unusual punishment. So man, I don't know, man. I don't know. Let's see. Let's see what's going on in the chat. And also, earlier Kurt said that he was going to be joining possibly in about 5 or 10 minutes from then. So hopefully he'll be coming in soon. Let's see here. JC says his behavior now is classic as per his personality disorders. He's been anxiously waiting for this day and getting himself worked up. He'll likely explode when he hears the comments. Oh, yeah. Yeah, that could be. That could very well be. I mean, and it definitely seemed like oh, Don Baca says he's a low to mid-range narcissist. His stuff isn't exhausting for him. It's fuel. Oh, that's crazy. Hey, Kurt, did you see that exchange?
I'm surprised. Darrell Brooks is a whole new man. I didn't really see that coming. His his contrition and acceptance of the court's authority is a refreshing change of pace. I'm glad that he's had time to reflect on his error of his ways.
Yeah. The thing that I wonder if he realizes on any level is the fact that she has the ability to determine how long he stays in jail and like what his incarceration basically looks like.
He does not realize any of these things.
You don't think so?
No.
You don't think there's a possibility that maybe he realizes but doesn't care?
I don't know. Yeah, I was honestly surprised that we got the subject matter jurisdiction thing again. I guess I shouldn't be, but I didn't have that on my bingo card for today.
Well,
When are we going to address subject matter jurisdiction? Well, I've looked it up, Darrell, just for the record. And as it happens, the circuit courts in the state of Wisconsin are directly given authorization by the Constitution itself. It's not even statutory. It's constitutional. So their jurisdiction is pretty much right up in your face.
Basically.
Yeah.
Basically. Yeah. I mean, I feel like subject matter jurisdiction at this point is basically habit for him. So, like it's like, oh, I'm talking to the judge. I need to talk about subject matter jurisdiction. It's like almost like a knee-jerk reaction at this point.
Do you? And also, which is a point that like only lawyers would probably really know, is subject matter jurisdiction is one of the few, if not the only issue that can't be waived. It's the only issue you don't. It's the only issue you don't have to preserve.
Mr. Brooks, if you interrupt me, I will.
You can raise it for the first time at any stage of proceedings.
Record regarding.
Anyway, Your Honor.
All right, he interrupted. I will mute him. I need
Tell
to make a
the appellate court all about it. They'll be thrilled.
The court did warn Mr. Brooks repeatedly that if he continued to be disruptive, the court would remove him to the other courtroom.
I will say, I feel like today she can have less patience with him.
I gave him the final warning, and then I indicated
the trial
I
is
would
already
be turning
over
to
at
the
this
state
point
to ask them some questions, and if he interrupted
I feel like she let that go on a little too long.
He immediately interrupted that.
Today.
Nothing matters at this point because there's no possible prejudice to him.
Put into the other
exactly.
The verdict's already and the judgment's already, so nothing matters at this point. So
technology.
What rights does he have at this point? Not much.
He can hear, he can see.
Which is why, like, I was kind of expecting her to lay down the hammer a bit faster. On
audible for a little bit when I first went on the record, but he continued to be disruptive, and so I did utilize the mute function of the technology.
And I'm disappointed to learn that there was no shock device. This is troubling and disturbing news on civil law.
Today, I will make a finding under Illinois versus Allen that his conduct was did disregard the elementary standards of proper conduct, of decorum and courtesy. He was disruptive. He interrupted.
JC, yeah, the judge is able to give comments, and there will also be statements from family members of the victims and things like that too. So there's going to be a lot of commentary on who this man is and what he's done to everyone.
I'm not going to do it today, but I will at a later point in time. perhaps after scheduling, I will have a deputy testify regarding the restraints that were utilized, so that there is a full and complete record about what was utilized and what was not utilized throughout
The
this
black
trial.
cloth,
It's
by the way, Darrell, was
absolutely
for
false
your
that
benefit.
a stun
It
belt
was to
of
hide the
any
chains
kind
so as to
was
not
used
unduly
on
prejudice
Mr.
the jury,
Brooks.
Darrell.
Yep.
I don't know if he's
To imagine
receiving that
you
information from
in
other
prison
inmates,
and to say that's where you should be.
but that was not utilized in this case. It was a soft leg restraint setup, if you
Yeah,
will,
I already got that
where
one.
he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the table. And it is absolutely true that there was a black table skirt on the tables, both
Yeah,
the
Ms.
state's
Amanda,
table, the defense
it's
table,
unfortunate that he learned it
in
from
this
such an
courtroom,
early age.
despite
If
Mr.
what you're
Brooks
saying is
believing
true,
that,
that's awful.
it was not done for his benefit. It was to shield that information from the jury. It's also true that at all times when he has been brought into court, it's been before the court has been open to the public. If this court needed to remove him to the other courtroom, it was also done with the courtroom closed to the public. That was, of course, a security decision made by the sheriff's department. They are in charge of his security as well as the court's security during any court proceeding in this courthouse. And it was their discretion.
JC, I expect them to have to move him into the other courtroom for that one.
And again, I'll go through that later and have a record made of what was utilized, including having one of the deputies identify what's on the exhibit. I'm not going to show that publicly. Again, there are security reasons. We don't, frankly, need inmates doing research or the public doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view, so that their protocols and practices have that, frankly, veil of secrecy. It's important given the security issues. It's a law enforcement function, and that is my decision on that. As far as Mr. Brooks being in the other courtroom, again, I did that pursuant to the authority found in Illinois versus Allen. I did not hold him in contempt. Frankly, because it's a scheduling type hearing, I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the
because she's a glutton for punishment.
With that, I am going to address scheduling. I will be asking each party in turn
You think
how
Mr.
much
Brooks
time
answers
they
the questions
believe
and how
they
many
need
people are
to
going to come
present their
for him?
various sentencing remarks and whether anyone
No, I
will
think-
be
Judge just says no.
speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like to
Wow.
either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom as they come in to speak, because we can't fit everyone in the courtroom at one time. So we'll need to get one set in, get another one to room 115 so that they can hear what's being said. So we're thinking 4 hours, and speaking with the families and the victims Wednesday after the verdict. I think there's a strong desire to have the sentencing before the anniversary of the parade incident, and that
makes
obviously is
sense.
November 21st. In checking with people, November 15th, 16th works for everyone. Specifically, the 16th works for everyone that would like to talk. I know that this court obviously has court calendars. I do have other dates that would work. Unfortunately, those go out to the end of December, end of November, beginning of December. But again, I can't emphasize enough. There are a lot of families who are leaving town the week of the parade, and I think the general consensus would be it would be nice for them to have some finality to this before they leave so that they're not around here at the time that a loved one was injured or killed.
By
Yeah.
any chance, did
They
you
wanna
have an
grieve on that
opportunity
day.
to look at my calendar and some of the jury trials and talk with your colleagues? I mean, one of the cases, for example, I have on the 15th is an attempted homicide trial. I don't know if that's going to go or not, but just like this court gave due attention to this case, I need to be mindful that that case has been scheduled since June.
Ooh.
I did not. I received these dates, although I believe that they were probably sent this weekend. I did not check my email over the weekend, so I did receive them this morning, and unfortunately, I did not take the time to do that. We can certainly look right now. Do you know who's handling that attempted homicide from our office?
I believe that's Attorney Sitzberger.
Okay.
There's other cases as well, because it's rare that I wouldn't stack trials.
Right.
And so there's also another serious felony matter with Attorney Thurston for your office. That one was scheduled in August. I have another one with you,
Yes.
Attorney Basie. I'm just looking at the number of.
I'm all in favor of sooner rather than later. The last,
Yeah.
I'd like to not hear from him
So we have
like
8
ever again
different
soon.
Defendants, many more cases, but 8 different defendants scheduled for jury trial on the 15th. The other thing is on the 16th, our CJCC has a very special meeting. I'm still the chair of that, and that is an anniversary of the CJCC that I do not want to miss. So not that I couldn't work around that, and it's not that I'm not willing to change, my calendar in any way that I can.
I can tell you, Attorney Witchow did reach out to Attorney Sitzberger. He indicated, and he said we could put this on the record, he's 98% confident that will resolve, the attempted homicide will resolve. Attorney Thurston is not in the office today, so I can't speak to that trial.
Yeah.
All right, let me, before we.
When's the anniversary again?
Dates, of
November,
course, let me talk with.
like 10th or 15th or
Mr.
something?
Brooks and find out.
I'm sure someone in the chat
how
knows.
he anticipates
By the way, bless you.
his sentencing remarks and whether anyone. So, sir, I have unmuted you. If you could speak to scheduling.
He's got nothing but time, Your Honor.
Your Honor, I would just like to say that
Oh, 21st. Okay. Thanks, guys.
I know you're well aware that I have ongoing matters in Milwaukee pending too. I have to be in court there in 2 weeks, and those cases are scheduled for trial as well.
Oh my God. He's got more court?
I haven't had the opportunity to
I just drop it.
speak with my representation over there because of the protocol that I've been on these past, I think it was 5 days since I last was in your court. I would like
Just
the
drop the
opportunity
charges.
to,
It doesn't matter anymore. Just
now that obviously this was the big case, obviously. If it pleases the court, if it pleases you, Your Honor, I would at least like to get a disposition on what might happen there. I go to court there in 2 weeks. I'm sure that I would learn a lot more at that time. I'm not sure if I'm going to have the same representation at this point or if something's going to change with that.
let's do sentencing next week then.
Do you know the specific date that you're scheduled?
The 17th.
Sentencing tomorrow.
That's for both cases. I don't know why they put both cases on the same date. And like I said, I don't know if anything's going to change between now and then. But both of those cases are scheduled to go to trial. And like I said, with the representation there, I don't know what's going to happen with that as of yet. There's been issues for months with that. I know that's something that Milwaukee has to deal with and not your court.
Sadly
but
true.
It would be a great help to me to at least be able to find out what I can find out about what can possibly happen there, and to also do any work that I may need to do on my end.
I mean, he's actually sounding kind of reasonable at this moment. I'm shocked.
So I have looked at the dates. You are right. There's a hearing on the 17th at 2 p.m. The trial, though, in that case is not scheduled until December 12th. So my belief would be I could certainly see the judge in that case understanding if we had to go to sentencing, or I chose to go to sentencing on those dates. And it looks like, again, both cases are scheduled for those same dates.
Yeah, it was kind of weird to me. I don't, the way they scheduled both cases on the same day was just kind of like, I didn't really understand why they did it like that.
Well, let's talk about a related issue, and that is, do you anticipate anyone speaking on your behalf at the time of sentencing?
Nice, Diana.
I do.
All right.
It's a good joke.
And do you know how many people you anticipate speaking on your behalf?
I don't know an exact number, Your Honor. Rough estimate, there'd be 20 or more.
I seriously doubt
yet
he has 20 or more people
with
going to
everybody,
talk on his
obviously,
behalf.
because of the protocol that I've been on. I haven't had the chance to. Essentially, some people will be traveling to Wisconsin from different areas, different states. And I know they've expressed wanting to be there to speak for that. But like I said, me, myself, not being able to have the opportunity to speak with them personally, I don't know exactly how many. And I don't know how many people will be coming from different parts of the states. I would ask, if it pleases Your Honor, to be able to have everyone that does want to speak and does want to address the court, to give them the opportunity to be here for that. I know there's, as far as the people that are here in Wisconsin that will speak, one thing that they was stressed to me is that how is everything going to affect what's going on in Milwaukee? So that was like one thing that came up, in because I had totally forgot that the Milwaukee court dates were this close. And so I was just like, yeah, you're right, 17th, that's 2 weeks roughly. I don't know exactly where we're at in those proceedings.
He's really good at
like
filibustering.
I said, there's still like some issues going on with the representation. I haven't been able to reach out. Obviously, I can't.
I think at this point we could do an over-under on how many people are actually going to show up on his behalf.
It's so true.
I've had very, very limited interaction with the current representation in those matters. So I don't know what pleases you, Your Honor. I don't know what pleases the court, but I'm.
And the old public defender speak on his sentencing, or is that attorney-client privilege problem because of the things they want to say?
They're going to be traveling from.
Yeah, right. Exactly.
And
I'd like to offer some testimony for the state at this point.
A little bit more information that I can provide to this court.
On this question, I don't know. Kurt, do you know the answer to this? On Suicide Watch, does he have access to the phone, or is family seeing him? Probably not.
I've done for other cases, and
yeah, I don't know the specific protocols either, but my guess is probably not, because they usually take pretty much everything away from him that could possibly be used.
Will also make available
to hurt himself
for victims, family members, including your family members, who would like to make a statement on your behalf. The only thing I ask, though, is I'm not just going to open up my Zoom to anybody. And so anyone
it's a
who
Zoom
wants
Yeah.
a relative, a victim, family member to speak, whether it be from the state or from you, Mr. Brooks, is I need to know who, no later than
tomorrow,
probably a couple of days before. I'm leaning toward scheduling this on the 15th, so that would be like the Friday before, which would be the 11th, so that when they come on the Zoom, they're identified, and then I let them in. So I understand your concern about Milwaukee, but if I hold this on the 15th and the 16th, by your description of how many people, by what the state
did anyone show up on his behalf in the trial? I only watched the end. He says, love living Peachtree.
From the parties,
He
And then
called
I
witnesses,
would
but I
come
don't think any
fresh
of them
the
were
next
actually
day
friendly to
give the
him.
court's sentencing. And so probably a day and a half, but I'd set aside both of those days just to be on the safe side, in case it takes a little bit longer for either of the parties to present their sentencing remarks.
Your I'm not interrupting.
Go ahead. Go ahead.
I was trying to make sure I didn't interrupt.
Okay.
Go ahead.
Your Honor, with all due respect, if it pleases the court, if it pleases your court, Your Honor,
I can think of
because
some
of my
things that would please
situation,
my court right about
I
now.
could benefit from a little bit more time. I'm not asking.
No.
I'm not asking for something outrageous here.
You got 2
Just
weeks.
enough.
Yeah, 2 weeks is
I
enough
can
to
tie
give
up
someone
some
a
of my
Zoom
loose
link.
ends, get you the information that you need to be able, if someone has to be present by Zoom.
Right. They don't even have to travel
or
from out of
whatever the
state. That
case
solves
may
your
be.
out of state problem.
Or to find out if these people are actually going to travel.
Darrell, call me.
And also
I'm available.
still be able to prepare
I'll be
for what
away.
I need to prepare for.
Be
Because
able to
obviously,
testify
I
on your behalf.
still, regardless of
Send me a
anything, I
link.
still have to be prepared to continue court proceedings. I still have to be prepared. It will really, really be a big help and a great benefit if I can have just a little bit more time to tie up the loose ends and get everything done in a timely fashion to be able to be ready to go and present what's needed to the court.
Absolutely not,
I understand
Darrell.
that, sir. The issue the court has is obviously if I wait much longer than that, I would, out of respect for the victims, avoid the week of November 21st. That's also Thanksgiving week. I don't think that would be an appropriate time for sentencing.
Get it done before Thanksgiving.
Then,
let these families have their Thanksgiving together. So they can be
I
thankful that this guy's in jail for the rest of his life.
My calendar is just incredibly full. I have some time off in there. I have trials almost every week other than the week that I'm off, all the way up through the week of December 19th.
Court sets a date in November. This is usually where the court says. Court sets the date at November 15th.
I wouldn't, and so
sorry if that's an inconvenience to the
puts us
defense,
into
but
January, and I'm not willing to do that. It's just
the 15th sounds like that's what it's going to be.
Of that trial, in case one of your cases goes to trial. So I think I'm giving the parties ample time. I'm giving alternate ways for family members to speak, and that is by Zoom or in person, should they wish to be here in person. And I'm willing to clear my calendar, even of those trials. Hopefully my trials resolve, but to the extent that they don't, then I will clear Tuesday the 15th. Wednesday the 16th, though, I would not start until later that day, given the meeting I have to chair for the Criminal Justice Coordinating.
Do it on the 15th. We all want the 15th.
So that's from 8:30 to 10. I need to talk with our executive director a little bit more because I know we have a special type of meeting schedule and I don't know if it will go longer. At a minimum, it would be safe to say the afternoon on that date. And no matter what, that would still clear Mr. Brooks to be in Milwaukee on the 17th. I mean, we're one county over. It's not unusual to do an order to produce that close.
I'm sorry.
No, so I am going to schedule it for the 15th and the 16th. The 15th will start at
no, just do it on the 15th. Be done with it.
8:30 a.m.
Just do the 15th. Be done with
depending on, I'll be ready to go no matter what on the 15th. And if the state takes into the afternoon and then Mr. Brooks needs the rest of that afternoon or into
Mr. Brooks is not going to have 20 people. We all know Mr. Brooks is not going to have 20 people, Your Honor.
Yeah, Stephen Yarger agrees with you. Thanks for the super chat, Stephen.
Say we're going to schedule it for 1 p.m. on the 16th. And if anything changes, I'll let the parties know. And then I just need to know by Friday the 11th at noon who the parties are asking make their statements by Zoom with a listing of their names so that when they appear on the Zoom, because then I'll approve it. We'll release the Zoom information. I need everyone to be aware, though, including victims, you may not your family members, and it may not just simply give this Zoom information out. It will be only for
Oh,
those
geez.
individuals that are
Yeah, that would be such a
identified by the
nightmare.
state as wanting to appear by Zoom. I want to keep a tight control over that. And if I don't see like a name either says a name that's been approved, like let's say you had a
Oh,
friend
no.
by the name of John Smith.
PayPal me is back. Maybe their
John
sovereign
Smith
citizen
doesn't
community is
say
going to show
put on
up.
their Zoom info,
Oh,
John
no.
Smith, I'm not, and it's just a phone number. I may not let them in.
Oh,
They have to be identified.
that would be a nightmare.
Can't just give it out to
They
anyone.
call me the state of Wisconsin.
And it's only
lived
for
it.
those individuals who want to make a statement, since the proceedings will be live streamed as well, whether that be how we've been doing it throughout the trial, or if I utilize the Zoom and the live stream I've done in the past, so that other people can watch it as well and to facilitate the smaller courtroom that we have. So that's my decision on that.
So she said 15th at 8 a.m.?
And at the
8:30, yeah.
Okay. Cool.
I want to just very briefly have, I believe it's going to be Deputy Kibler who's going to testify about the restraints.
Your Honor.
Yes.
Uh-oh.
I'm not trying to interrupt.
Yes, you are.
Just do it.
You said, when is this supposed to be? Because I'm definitely
15th.
gonna need a little bit more time than
No, it's the 15th.
Mr. Brooks, I've made my decision. The sentencing will be on the 15th and the 16th of November. Anyone who wants to appear by Zoom on your behalf, you must file a request in writing no later than noon on the 11th. The same is true for the state. Everyone needs to be specifically identified so that I can make the appropriate approvals, and only those individuals who I specifically approve to appear by Zoom may be on the Zoom. The Zoom
Works for me.
information can't be passed out further. And I'll create a special Zoom for that, and I'll make sure that I work with Teresa to do that and get that information when I approve that to the parties.
Your Honor, what if I'm placed on a protocol per the jail? What if
Mr. Brooks, that's between you
That's-
and the
that's on
jail
you,
at
sir.
this point.
Yep.
If there is something you need
Tell
to
it to
first go through
someone. Who
them.
cares?
Want to step on their toes with their protocols. I'm sure they'll understand this is a very important sentencing for you and make certain accommodations. They've done that throughout this case. I trust that they will do that as they determine is appropriate.
they haven't done it for the past week when I went on a protocol without even telling them anything suicidal in nature, and I was still placed on a suicide watch protocol.
I understand that, sir. I need to move on because I do have calendar this afternoon, but I want to
Excellent. Keep
Detective
going.
Kibler come to
Yep.
the stand.
Your
Kibler.
Honor,
Deputy,
Well-
what did I say? Detective, did I give you a promotion? Sorry. All right.
but
He's going to come on up to the witness stand. I'm going to
But-
swear him in, and we'll go from there.
Just keep moving.
for the
Yep.
record, may I respectfully object to your ruling, Your Honor?
Nope.
No.
It's noted for the record. All right.
Doesn't
Madam,
matter.
swear him in, please.
For the record, may I respectfully request a legal reconsideration?
Oh, we're
Nope.
doing this thing again?
No.
I need to keep going, and I can't.
Aye.
It's disruption. Go ahead.
Let's
Raise
mute
your
him.
right hand.
Excellent. Good for you, Judge. Show some cojones.
Yeah.
All right. Thank you, sir. Have a seat. I'll let you put your name on the record so I don't get that wrong. And so go ahead. Please state and spell your first and last names.
I don't know if
First name
you guys
Nicholas,
can see, but
Nicholas,
Indy's a dinosaur today for Halloween.
Kibler,
Of course.
All right. Thank you. And you are employed in what capacity with the Sheriff's Department?
I'm a deputy for the Waukesha County Sheriff's Department.
I don't think so. I know. We don't have a meeting. All right, sir, were you assigned to the trial of Darrell Brooks?
I was.
And can you tell us in what capacity?
My capacity was specifically, my responsibility was Darrell Brooks, along with Deputy Stengelson.
And
And-
were you in court at the start of the trial on October 3rd?
I was.
And did you come into court or work the court trial every day that we were in session?
I did.
And can you, were you at all in charge of the restraints? Let me ask you this. Do you have knowledge of the restraints that were utilized on Mr. Brooks
I
throughout
do.
this trial? Can you describe those, please?
It's a soft restraint that we used. It was not any type of electronic control device. It was just a soft restraint that we applied to Mr. Brooks prior to coming into court every day.
And would that be a restraint system that was on his legs or something else?
It was around his ankles.
All right. Throughout the trial, the tables in this courtroom had black table skirts. Do you remember seeing those?
I do.
And did that hide from view in any way the use of the restraints from the jury?
It did.
And were the restraints also attached to the table in some fashion?
They were attached to the table by a tether.
At any point in time, were there any other restraints utilized in the courtroom?
There was not.
At any point in time, were there any type of electronic or stun device placed on Mr. Brooks?
There was not.
Anything you would want to add to the record regarding the restraints that were used in this case, sir?
Not at this time.
State have any questions?
Just briefly, Your Honor. Sir, you indicated that the restraints were connected to the table through a tether. Is that correct?
Correct. And then we would secure them with a padlock.
And how
on the
long was that
restraint.
tether?
The tether that was in here was 4 feet.
So Mr. Brooks could stand up.
Correct.
He could walk to his left briefly and walk to his right. Is that correct?
That's correct.
And that was the same rule that the state had, that we had to stand up and use our table to question witnesses. That was the same rule that applied to Mr. Brooks.
Correct.
Okay, nothing further.
Mr. Brooks, you're unmuted. Do you have any questions regarding the restraint system? as
Oh, no.
testified to by
Here goes.
Deputy Kimber?
Yes, I do. And Your Honor, you can't practice law from the bench.
Question, sir?
What?
So, none of your fellow deputies told me that it was a shock device when I asked what was being placed on my ankles at the start of this trial.
Not that I'm aware of.
Not that you're aware of. Do you know for sure that I was told that they were a shock device?
I don't believe that's the truth. I believe every time you had those devices put on, I was in there, and it was either myself or Deputy Stengelson putting them on, and I did not tell you that, nor did I ever hear Deputy Stengelson tell you that they were an electronic device.
So you were here every single day for every single moment of the trial?
Correct.
Pretty much.
And you never heard any deputy tell me that they were, matter of fact, let me back up. Do you recall me asking what was being placed on my ankles?
That I don't. If you did, we would have told you it was just an ankle restraint.
And you said that it was an ankle restraint. Did it have any metal parts?
Yes.
And what are those metal parts?
Metal part is where a strap went through and the locking device.
And what are those particularly, let's say if a defendant in a trial attempts to, let's say, attack someone, what would be the purpose of those ankle restraints?
The restraints we had
prevent
on you
from-
would limit your movement. So if you did try to do anything, we would have had enough time to control you.
So
Lol.
on the ground
And
in the
you
chat,
state that
he's testifying about the ankle restraints to
Well,
show that there was no
the,
shocking device on them.
the prosecutors stated that the same.
And Maria, thanks so
rules
much for
were
your
in
super chat.
effect for the defendant as the prosecution, but were they not allowed to put up exhibits to go to the front of the courtroom and put up exhibits?
They might have a few times, but
The record will reflect it was one time in the presence of the jury, and after that, I called them on it and said that would not happen. And then after that, it was only with the permission of the court and then outside the presence of the jury.
I don't believe that, Your Honor, you can practice law from the bench and answer.
Not practicing law.
Mr. Brooks, I'm in charge of the record, not you, and the record's going
I
to
didn't
be
say I was-
accurate.
I didn't say, well, it's not accurate. You're practicing law from the bench.
All
No,
right,
she's
Mr.
not.
Brooks, do you have any other questions for this?
Yes, I
witness?
do. Yes,
All
I
right,
do.
it has
Before
to
you
be
start-
about the restraint system. Please
Okay,
continue.
and was I allowed to approach the bench and put up exhibits at any time during this trial?
you were not.
And so how is it that the prosecution was able to do something that I was not able to do.
Oh my God.
That's not for me to answer.
It's because of the shock device that was put on my ankles, correct?
There was no shock device.
There was no shock device on your ankle, sir.
I was told that it was.
Oh,
You said
God.
that you don't recall.
Okay, this is
hearing that
where the
being
judge
told to
comes
you,
in and
correct?
says, well,
No,
thank you.
it
That's
was
the end of
not
your
told to you
questioning.
by
All
me.
right, asked and answered.
Yeah, by you, but you also said that's the point that I'm getting at. I'm asking the question. You said that it wasn't told to me by you. I never asked you, correct?
You never asked me, but I also did not ever hear Deputy Stenelson tell you that they were a shock
I
device.
never asked you. I never asked you, yes or no.
No, you did not.
So do you know for sure if I ever asked any other deputy?
Well, considering I was in there when the restraints were being placed on you, I did not ever hear anybody while I was inside the bullpen while they were putting restraints on you.
So it'd be fair to say that you don't know for sure if I ever asked what the device was that was being placed on my ankle.
No, I can't be for sure.
So how do
Dude.
you know I didn't ask?
Dude,
You don't have to answer that. That's argumentative.
I mean,
All right, the record's been made. Mr. Brooks, I'm cutting off the questioning. I'm
Thank
just muting him for a
God.
moment. The record's been made. Deputy, you may step down. Mr. Brooks, if you have additional information that you want to provide to the court, I'd ask that you do so in writing and you provide the identity of any and all individuals you claim provided you with information that you were in a shock restraint. But I'll make a finding based upon the testimony of Deputy Kibler and also my knowledge of being in the courtroom every day and seeing Mr. Brooks being attached, meaning they would secure him to the table, they would unsecure him when he needed to move and other things. I'll make a finding that the soft restraint system was what was utilized and at no time was he ever in a shock type of device. All right, with that then, ladies and gentlemen, it is going to conclude the hearing today. We have the sentencing dates. I would also ask that any and all written material that either side wants this court to consider also be filed by the 11th.
Darrell's not going to turn anything in.
Noon.
That's my prediction.
So that's November 11th at noon. That will give this court ample time to review it ahead of the hearing on Tuesday, November.
I would be shocked if
15th.
there was anyone to testify on his behalf.
Thank you, everyone. We are in recess. The court's going to take a short break before I start with my remaining afternoon calendar.
All right.
That's
great. That's going to be it.
Yeah.
Cool. So until the November 15th, November 15th.
Yeah, I think we'll be done by November 15th. And I would imagine that the state might drop those charges for the witness intimidation with the whole 6 life sentences consecutive thing. It's like, well, yeah, probably don't need to adjudicate that case anymore.
I mean, why waste court resources, right? Because he will absolutely waste them.
Yeah, exactly. So yeah, I think I'd be strongly inclined to drop it.
Yeah.
Also, for what it's worth, when he's talking about like practicing law from the bench and stuff like that, there are different systems of judges in different places, and it's not common, although it's not unheard of either, for judges to be part-time or for them to, be specially appointed for a particular case or whatever. So like, yeah, I mean, you could be a lawyer one moment, the judge the next, and back and forth, depending on, jurisdictions do a lot of weird stuff when it comes to things. So yeah, you have people who are sitting on the bench and that's all they do. You have lawyers, that's all they do. You have people float in between status. And in no cases, any of it practicing law from the bench. That's just dumb.
Yeah.
It's all stupid.
Yeah. So he definitely doesn't know what he's talking about when he says that she's practicing from the bench, because she's not. No. She's not. She's not advising him. She's not helping him out in any way. She's not acting as his lawyer. So that's how that would actually be looking in this kind of a scenario.
Yeah.
But yeah, it's like I feel like he has a conversation with someone back at the jail or back in prison, and they like some sovereign citizen, and they're like, "Oh, well,
Yeah.
did you talk about this?" And they give them like a new buzzword, and then he's
Yeah.
like, "Oh, okay, practicing from the bench, Your Honor, you're practicing from the bench. Don't know what it
I
means,
mean,
but you're doing it."
it's even possible that she doesn't necessarily have an active law license because she's a judge. She's not practicing law. I don't know. There are probably judges out there who don't have active law licenses because they don't maintain them. Because why would they? So yeah, it's all dumb.
It is. It is indeed. But the good news is he's guilty. He's going to prison for the rest of his life. And it looks
He's
like
going to super prison, and then he gets to tell the appellate court all about the subject matter jurisdiction. I'm sure they'll be thrilled.
it's going to be awesome. So yeah, so 15th. So, and also the best part is for the families, they get to have this completely wrapped up before the anniversary of the deaths of their family members. And then also before Thanksgiving. So they can just
Yes.
enjoy having Thanksgiving with one another and just be done with all of this awful darkness. So, all right. Any last thoughts?
Well, I just want to talk about some things that are up and coming on my channel if I can.
Yeah, absolutely.
All right. So today I will be posting a video regarding a Supreme Court oral argument that was heard earlier today, giving a little bit of a highlight out of it. It's, at least for my money, the biggest case of the Supreme Court term. Students for Fair Admission versus Harvard versus UNC, dealing with racial-based admissions in colleges. We're also going to be doing a Supreme Court oral react in a couple days once the audio and text are synced. So we're going to go over that. That's going to be fun.
Is it for that case?
Yeah, for that case. Yeah.
Can I maybe
So,
join you for that?
Yeah, sure. Yeah, absolutely.
When are you doing it?
Well, it usually takes a day or two for the audio and text to be synced. So probably Wednesday or Thursday, I would guess.
Okay.
I mean,
all right.
both the text and audio are available, but
Yeah.
I like the synchronization, and that usually takes
it's good. I agree. It's a much better overall viewing experience.
Yeah. So that's coming up on my channel. And then also coming up on my channel, we have some other things that are coming up. Alabama man, story of Alabama man giving Florida man a run for his money.
Okay.
An army guy who decided to murder another army serviceman for reporting on him for smoking marijuana.
Oh no.
And that 70, and we also have a story coming up about the 70s show, Danny Masterson, an article covering that ongoing trial. He's on charge, being charged with 3 different cases of sexual assault, and 2 of those victims have testified so far, and things are not looking great. And of course, as you've been talking about on your channel, Scientology is involved. So fun and exciting stories coming up on Unsealing the Law.
Yes. Yeah. And we'll be talking about the Masterson case tomorrow on this channel as well. Getting through some updates and whatnot. I'm also talking to some folks that are possibly another former Scientologist, hoping to schedule a time with Tony Ortega also. That might just be a random weekend stream because he's so busy with actually watching the trial, actually being in the courtroom. So anyhow, so a couple people that I might be having on my channel to talk about this case should be interesting. But otherwise, tomorrow updates on that case and probably the Harvey Weinstein case as well. So
good times.
Fun times. There's just so much law.
There's too much of it happening.
Alrighty. Well, okay. So that for me about does it. Any last thoughts?
No, I'm good. I enjoyed our time as always.
All right. Same. And happy Halloween to everybody. I hope you have a spooky day, but not as spooky as hanging out with Darrell Brooks. Alrighty. I'll see you guys in the next video.